Present remotely from my annex office.
Thank you. Representative Scott.
Present.
Representative Stevenson. Representative Banta.
Here in the room.
Chairman Massey.
Here in the room. Thank you. We certainly do have a quorum. We have 3 matters on the agenda for today. And the first matter is going to be House Bill 263. I sponsored this bill, but I'm going to remain up here. We do have a special guest here today with the speaker. This is a family from his area. And Kira, who is here with us today, this is not her first bill. She has worked with Kentucky Youth Advocates, and this is not her first opportunity to present here, but she is a tireless advocate, and she tells me someday, if the speaker ever gives up the gavel, she might want to hold that seat. So with that, I'm going to basically just give a very quick overview. It's a very short bill, and basically it deals with a statute involving criminal abuse. KRS 508-100 would be amended that if the criminal abuse occurred to somebody less than 12 years of age, it would be elevated to a Class B felony. And that's the change in the statute. And there is a committee substitute on this bill.
Second.
Okay, we have a motion and a second. All in favor signify by saying aye. Aye. The committee sub is adopted. The purpose of the committee sub, so that you know, is to make it named Cammy's Law, correct? Yes, Cammy's Law. I want to say it right. And so that is going to be the name of this bill. And with that, I'm going to turn it over to the speaker first, and he can introduce his guest and the family, and then we'll hear from Kira.
Thank you, Mr. Chairman, members of the committee. It's a privilege to be here today to help Kira present this bill. This evolved from a summer meeting where actually going back a couple of years ago to when Kira and her family were here advocating for another bill. And when we passed that one, she promptly told me that she would be back with a new issue pretty soon. And it took her about 3 years, I think, to come back with this issue. Met with her this summer to talk about it. And then it was completely and totally over my head, which most things are these days, it seems. But so I put her in touch with staff and Mr. Chairman, yourself, to help her in developing this bill. And she's taken it through KYA and has done an outstanding job of advocating for it. It's such a rarity today to get young people involved in public policy. You see the rancor of politics and all the things that we all get tied up in. And so to see somebody that is able to operate in that system for productive purposes without ever getting mad about it, without ever calling anybody a name about it, and without ever really caring who is a Republican or a Democrat, it is very refreshing. So with that, Kira's family is behind us here, but I will turn it over to Kira for a presentation.
Thank you. I'm going to share a speech. Cammy was a beautiful 9-month-old baby when her life was forever changed when the man responsible for her safety shook her so violently that she was clinically dead for 23 minutes. Cammy survived, but due to trauma, only half of her brain remained. Since that day, she has been confined to a wheelchair, nonverbal, requires a feeding tube, daily seizures, and has to take 12 pills a day and may never be able to use the bathroom on her own. Last year, Cammy had to have her fake skull replaced, got sick, and almost died again, while the person responsible roams free with no legal or finance recourse. The county's attorney handed him a deal of 5 years in prison, of which he did not even serve the full time. Kentucky has the highest child abuse rates in the nation. We need change. In Kentucky, child abusers can still visit the child they abuse after they get out of prison. when they plead down to a lesser sentence, keeping them from registering as an abuser. Reported child abuse passed 20,000 in 2019. That's about 20 out of every 1,000 children. A little over half of child abuse cases are reported in Kentucky. This bill becoming law will help us address these terrible numbers by preventing the state from handing out soft deals to people who harm children under the age of 12. The important consequences of these violent actions must be a big felony and serve the time they deserve.
Thank you very much. I know you've worked very hard on that. We've, your guest, I know you didn't call them out by name, but we have here the mom and dad, which is Andrew and Brandy Dunk. And then we have, I think, cousins. Is that correct? Or is it? Yeah. We have Okay. And that's Harper and Alex. Is it? Okay. And she's worked very hard on this bill, and she wanted to address this body. And so she has worked tirelessly. So we worked this day to make sure this happened for her and her family. She was very passionate about bringing this bill. So what I'm going to do now, Kira, is open up the floor for questions about the bill, if they would like to do so, directed either to yourself or to the speaker, to myself. And we'll be glad to address any questions the members may have. Representative Scott.
Thank you, Chairman. And I'm not sure if this question is for you or for Mr. Speaker, but what's the difference between the original bill and the substitute?
The only thing the substitute did was name the bill. So it only names it as Cammie's Law in reference to the story that was told to us here today by Kira.
Thank you.
I just have a comment.
Representative Hebron.
Thank you very much, Chairman. I just want to say I'm so proud to see a young lady sitting up there with the Speaker of the House. I am the youngest member of the Kentucky General Assembly, and I'm just really proud to see another young female up here advocating and using her power and her voice to advocate for good legislation. So thank you so much. We're very proud of you, and we're glad you're here today.
Representative Blanton.
Thank you. Just a quick comment, Mr. Chairman. Thank you for bringing this very important piece of legislation. And I just want to point out why it's needful, not only from your story, but as I pointed out in committee with data that was provided to us over the past 2 years with these shutdowns, we've had over a 50% increase in children dying at the hands of their caregivers in this state, not nationwide, in this state. Over 50% increase. That's something that we need to be concerned about. Thank you for what you're doing.
Representative Nemes. Mosier.
Over here, Kira. Thank you for bringing this. I know your mother was very excited about it. I know you are. She's contacted us a number of times. The speaker who's sitting next to you was excited about this day also. He's made sure that we were all in our seats and ready to go for you. And so this is great advocacy. I have 2 questions. My first question is, what's your next bill? You got another one coming, I'm sure. You've done a great job. And the other one is, Derek and I have some bills we need some help on. Can we get you to help us? So,
Sure.
Great job. On all seriousness, this is a very important issue. And I'm very proud to represent a little bit of Oldham County, where you're from. I know you're the speaker's constituent, and I just want to say, thank you for doing this. It's important to thousands and thousands of people who they'll never know who you are, but they'll benefit from your work. So thank you.
Representative Mosier.
Thank you, Mr. Chair, and thank you so much for being here today. I have a couple of questions, but I too want to just echo what my colleagues have said. I'm really proud of you for standing up for a really important issue and educating the Speaker of the House on this issue so eloquently. Thank you. Thank you, Mr. Speaker. This is a good bill. I do have a question. You said when a violent perpetrator is cited that they don't need to register as an abuser. Will this bill, maybe Mr. Speaker, you can answer this, when we move this to a B felony, does this ensure that the violent perpetrator registers as a child abuser? and then, keep them from interacting with the victim in the future?
I will defer to Chairman Massey for the specifics, but I do believe that the process of registering was, since it can't be pled down, it doesn't reach that point where you don't have to register. Is that correct, Mr. Chairman?
Okay.
Thank you. Yes, the purpose of the bill, there's several changes that have been made over the last few years about what is classified as a violent versus a nonviolent crime. And so one of the two reasons for bringing this is to make sure that raising it or elevating it to the Class B level makes it a violent crime which should be subject to registration. Also, in some cases, if you charge it as a Class C, many times it's mitigated down through plea agreements to the point that it becomes either expungible or the person may not serve much time, if any time at all, if it's negotiated downward. So making it a Class B, and the way the statutory codes read, is a Class D is 1 to 5, Class C is 5 to 10, Class B is 10 to 20 years. So when you have a violent offense, though, you're required in most cases, when it's described as a violent offense, to serve 85% of your time. And so someone that commits this act, especially on a child under 12, would therefore be designated as a violent offender, and then would be more likely, there's always arguments that can be made, but be more likely to serve that 85% of their time.
Okay.
Couldn't have said it better myself.
Thank you so much for that clarification. I think that really helps those of us who are not lawyers understand the importance of this. And I, again, thank you for your bringing this. Thank you.
Seeing no further comments, Madam Secretary, please call the roll.
Representative Banta,
Yes.
Representative Blanton, Representative Bratcher,
Yes.
Representative Cantrell, Representative Decker,
Yes.
Representative Elliott, Representative Fisher,
Yes.
Representative Hebron,
Yes.
Representative Colcarney,
Yes.
Representative Lewis,
Yes.
Representative Maddox,
Yes.
Representative McCoy,
Yes.
Representative Minter,
Yes.
Representative Mosier,
Yes.
Representative Nemus,
Yes.
Representative Petrie,
Yes.
Representative Scott,
Yes.
Representative Stevenson, Chairman Massey.
Yes. Would anyone, if somebody was gone? Representative Elliott, would you like to?
If I could have the staff bring me over my packet, I'd appreciate it, but I will vote aye.
Thank you. All right. How many yes votes do we have? Okay. There being 17 yes votes, 0 no votes, and 0 pass votes, this will be reported with favorable expression that the same should pass. Excellent job. Thank you to the family for being here as well. Thank you, Mr. Speaker, for bringing this young lady forward to present this. An excellent piece of legislation, and we thank you for bringing it.
Thank you, Mr. Chairman, members of the committee.
All right, we'll transition into our next bill. Oh, by the way, I meant to, if I didn't record it, that was the bill approved as amended by the committee sub. The next bill is House Bill 220 that's sponsored by Representative Hale, and he has a guest with him here today, so I'm going to ask him to identify himself and introduce his guest, and then you may proceed.
Mr. Chairman, thank you very much today. I appreciate the opportunity to be here today. I am Representative David Hale from the 74th Legislative District, and I have joining me today the Commissioner of the Kentucky High School Athletic Association, Mr. Julian Tackett, and I will be brief before you today. I come before you in the committee today to present to you House Bill 220. After hearing the presentation that was given to us in the previous bill, I feel almost inadequate today to come before the committee, but we come before you today with a situation that is certainly something that is very troubling to me, to the commissioner who has joined me here today, and to many, many people across the state of Kentucky. And it is a problem that has developed over the course of several years. And it is a lack of officials, sports officials, that we now have in Kentucky to be able to officiate our high school football, basketball, baseball, volleyball, not only that, our elementary games, our junior high games, even on the smaller levels than that. But what my bill that I'm bringing before you today is, it's very simple, and I'm sure you have a copy of that before you. It actually is very simply stated that this piece of legislation is intended to protect the officials of this state, not only on the high school level, but also this would also include collegiate level officials as well, that many times are threatened. They are on occasions physically harmed. There has been threats brought against their families. There has been things that has happened, accusations against them, against businesses that they owned. And so what we are facing here, of the games that we all love here in the state, let's be factual, we all love to watch our kids play basketball and football and baseball and whatever the sport may be. But what is happening, and I'm going to let Commissioner Tackett address this in just a moment, we have now such a shortage of officials in this state that we are currently looking to have to combine nights of having games. We can't cover all of the games that's out there because we have a shortage of officials. And I believe, Mr. Chairman and members of the committee, it is a absolute correlation between what officials are having to put up with and the abuse. And I'm not talking about just an irate fan in the stands that's hollering at the official, he or her. This goes far beyond that. I am a former official for many years. I officiated many years in high school sports here in Kentucky. And over the course of my years of doing that, I saw things happen on the court, on the fields, and some of those even escalated to areas of the parking lot or even off the school grounds, that some of those would escalate to. And so what this bill does, it would make this an offense which would be a Class A misdemeanor. And I'm going to be very frank, I really wanted to make this stiffer than that. I personally felt it should have been a stiffer penalty than a Class A misdemeanor. But to get the bill possibly heard and to get the bill passed, I went with those actions right there to make this a Class A misdemeanor. And again, I'm very troubled by what we're seeing happen in this state. And I would, at this point, Mr. Chairman, if it would be appropriate, I'd like for the Commissioner of the Kentucky High School Athletic Association today to just share with the committee the problem that he is seeing as he oversees this our athletic contest here in Kentucky.
Thanks, Representative Hale. I'll be very brief because with respect to your schedule. We are in a tremendous shortage over the last 3 to 4 years. It's not all COVID related. We're down in Kentucky, we're down about 25 to 30% of the available pool of officials. And what has happened over the last few years, our schools have thrown money at the problem. Our organizations have increased fees. It's not money. That's not the reason you're losing it. It's the environment. It is what they're subjected to. We've been here a couple of times over the past to support efforts to do that. I realize probably when both Representative Hale and I were both refereeing, we probably had a lot of people that didn't like what we did, but they seldom threatened us. And that is almost an every night thing. You recently saw an issue come up just outside of Lexington that is indicative of what's going on around the state. People are just basically, I think law enforcement feels like it's an all or nothing. They've got to go all the way to a much more serious offense. This gives them a much better tool in their toolbox to help get this point made, and we really wholeheartedly support it.
We have a motion on the bill by Representative McCoy and a second by Representative Lewis. And we do have a question by Representative Elliott.
Thank you, Mr. Chairman. Thank you, Representative Hale, and thank you, Commissioner Tackett. I think we've had this bill previously.
Yes, sir,
and
we have.
we've passed it with a different sponsor. And this question is for Commissioner Tackett. Is some of this related to the ability of the association to make payments to our officials? I know, years ago I looked into doing it. I play an official every weekend on my couch, watching these games. But I know that the pay is not a lot, and of course the association can't afford to make large payments. But what part of this is due to that? I agree with Representative Hale. I think that we do see inappropriate behavior in our sporting contests, and it's unfortunate to see it at the amateur level. I know we see it at the professional level, but it's really unfortunate to see it at the amateur level. What extent is due to the level of pay that
Well, thank you for that question, because it also gives me a chance to clarify a couple of things. As it relates to school-based sport, the payments are made by the schools, and there is varying degrees of how quickly they do that. We are blessed in our state. About half of our school districts have adopted an electronic platform called RefPay, which electronically pays them as soon as they're certified that they were there, and that has been a big help. We still have some schools have a little bit of a problem with our military bases being a little bit slow. But that problem at the high school and middle school level is not what it was before. It's been solved. They have to pay within 7 days. The actual amount of pay will always be up for debate, and there's a lot of local negotiation that goes on. We set a standard fee at the high school level, but that does not apply to the junior varsity and freshmen. And there's a lot of there's some community engagement there to try to figure out what's the best rate. The biggest problem that we're facing at the school level is as soon as we recognize a problem and raise the school officiating fee, the local leagues raise what they're paying to incentivize the people to do the games that are 5 miles from their house instead of traveling on a snowy night. And so that's probably something that will never stop, but the mechanics of payment is much better than it was. Much better.
Thank you.
Mr. Chairman, could I just add one?
Absolutely. You've been hot today. This is your second committee bill.
And I'll be very brief. We all know, and I know I'm sitting in a room here where there's some attorneys here and lawyers, and we all know that there are things in place that people can already be charged with an assault on an attack of someone. But I believe, in my opinion, I think we have to look at this from the consequences of what is happening to our athletes that are playing in our local sports teams, that it is almost impossible now to keep up with the amount of games that we have with such a shortage of officials. And in my conversation with the Commissioner Tackett even last night, he shared with me that there was instances that was probably going to be coming up soon that they would have to cancel contests because they could not cover when they have a group of games, maybe 15, 20, 30 games in one area. They do not have the amount of people to cover that because of the shortage. And to Representative Elliott's question, Representative Elliott, I've done this for a long time. It's kind of like being a legislator. If you figure up your time, if you figure up the hour, what you make per hour, it's very, very small. But I don't think on our level where I did it in the high school level, we don't do it for the pay. We do it because we love the game. We love the kids. Commissioner Tackett.
Yeah, the only thing I will add, any tool you can give to help this problem is going to be good.
Yes.
Or you're going to be back asking, how come your local games are canceled? How come little Johnny and Janie didn't get to play? It's coming down the road very quickly.
Thank you, Mr. Chair.
And thank you, Representative.
All right, seeing no further questions, we do need a motion on the bill. We have a motion on the bill?
Motion.
Oh, we did. We don't have a committee sub. Okay, we're good. Okay, Madam Secretary, please call the roll.
Representative Banta,
Yes.
Representative Blanton,
Aye.
Representative Brotcher,
Yes.
Representative Cantrell, Representative Decker,
Explain my vote. I'm going to vote yes today to move it on to the committee. I am still studying the bill. I'm a little concerned that the remedy does not solve the problem, and that it might be too far of a solution. So I'm studying it, and I appreciate you bringing the bill. Thank you.
Thank you.
Representative Elliott.
Aye.
Representative Fisher.
Yes.
Representative Heverin.
Yes.
Representative Cole Carney.
Yes.
Representative Lewis.
Yes.
Representative Maddox.
No.
Representative McCoy.
Yes.
Representative Minter.
Yes.
Representative Mosier.
Yes.
Representative Nemus.
Yes.
Representative Petrie.
Yes.
Representative Scott.
No.
Representative Stevenson. Chairman Massey.
Yes. With there being 16 yes votes, 2 no votes, and 0 pass, this will be reported with favorable expression that the same shall pass. Thank you, gentlemen, for being here and for presenting this bill.
Thank you, Mr. Chairman. Thank you, members of the committee today. We appreciate your time.
Thank you. You've had a busy day. All right. That being said, as we transition to the next bill, which is going to be House Bill 222, we are going to, being the Judiciary Committee, make a technical correction. We got so giddy about the testimony earlier today that nobody made a motion on the original bill, even though we voted favorably. So we're going to do it again and give Representative Blanton the time to register his vote. So do I have a motion on the bill with regards to House Bill 220 as amended by the committee substitute? We have a motion by Joe Fisher, Representative Fisher, and second by Representative Lewis. Madam Secretary, please call the roll.
Correction, Mr. Chairman, point of order. You called 220. I think it should be 263.
You're correct. Thank you.
Thank you.
Come on, Ed.
I know it. It happens. Motion on 263 as amended by the committee substitute. Motion made by Representative Fisher, seconded by Representative Lewis. Madam Secretary, please call the roll.
Representative Banta.
Yes.
Representative Blanton.
Aye.
Representative Bratcher.
Yes.
Representative Cantrell. Representative Decker. Representative Elliott. Representative Fisher.
Yes.
Representative Heverin. Representative Cole Carney.
Yes.
Representative Lewis.
Yes.
Representative Maddox.
No.
Representative McCoy.
Yes.
Representative Minter.
Yes.
Representative Mosier.
Yes.
Representative Nemus.
Yes.
Representative Petrie.
Yes.
Representative Scott.
Yes.
Representative Stevenson. Chairman Massey.
Yes, and Representative Decker, I know you stepped out a minute ago. We were making a technical correction on House Bill 263 as amended by committee substitute. Would you like to register a vote?
Yes, thank you. Yes.
And Representative Maddox, I know you're appearing remotely. We could not hear clearly your vote. This was on House
Chairman
Bill.
Massey?
Yes.
Chairman Massey, on House Bill 263, I am a yes.
Thank you, Representative Maddox. We just wanted to make sure. Thank you.
Thank you.
How many do we have total? 18. 18, yes. As indicated before, we have 18 yes votes, 0 no votes, 0 pass. The same will be reported with favorable expression that the same shall pass. Thank you for your indulgence, committee members. Again, that was a great presentation, and I think we just all got it a little bit ahead of ourselves, so thank you. Now we have with us House Bill 222. We have Representative Kulkarni and Representative Nemus, and they have a guest. And this bill also has been before the interim, and I believe it was discussed maybe in the last session as well. So we've been on this bill for quite some time, and I know that Representative Kulkarni has done extensive research on this bill because I've seen it. And so thank you for that. And I believe that we included or sent an email out today to the members of some of the research items that you presented. So that's also with our members. With that, I'll ask you to identify yourself and please proceed.
Thank you. State Representative Nima Kulkarni.
State Representative Jason Nemus.
John McGarvey, and I appear as one of your uniform law commissioners, as you know, Mr. Chairman.
Yes, sir. You may proceed.
Thank you, Mr. Chair. Thank you, members of the committee. Many of you may remember the interim hearing where we did go a little bit in depth into what anti-SLAPP legislation is. Fundamentally, the bill creates a special motion to dismiss that can be used to protect claims that involve matters of public concern or public interest from frivolous, meritless lawsuits that are filed in order to chill that speech or deter it. I think that we can just quickly go over some of the main points in the bill. There is a slight difference from the bill that was originally filed. I don't know if we need to make a motion to adopt that.
There is a committee sub, so
move
motion on the
second.
And there's just one phrase that
All
was
in favor signify by saying aye.
Aye.
Aye. Opposed? None. The committee sub is adopted.
Thank you. And there was just one minor change in a phrase in that bill. Basically, the main points to consider here are that anti-SLAPP legislation is designed to protect the core values of speech, press, petition, and assembly on matters of public concern or interest that are secured by the First Amendment. It provides an expeditious process, so the bill provides for 60 days to file a motion under this bill, 60 days for a hearing to take place, and then 60 days for a judge to rule in that motion. It stays proceedings unless a judge decides that there is a special need or some discovery needs to take place in order to rule on the motion. There is an interlocutory appeal for within 21 days for the moving party. And again, I think fundamentally the framework that we need to remember and the context that we need to remember is this is only going to apply to matters of public concern or public interest that are constitutionally protected. So it is different. I've filed a version of this bill since 2019, have had a lot of input, a lot of feedback, a lot of changes that have been made to end up with this version of the bill, which is very, very tightly narrowed and construed so that we don't have this issue of inconsistency and confusion among the courts. So with that, I guess I'll allow either my co-sponsor, Representative Nemes, or Mr. McGarvey to speak.
I'll just say that there's not much more I can add. Representative Kulkarni has it. She's the expert on this bill. I'm here just to help her answer any questions. She won't need it, but I do think John McGarvey, who's a constituent of mine, so I hope he gets an opportunity to speak.
We'll let him speak in
then
just a moment. We have a motion on the bill by Representative Heverin and a second by Representative McCoy. We're going to go to questions and Mr. McGarvey, but I will ask you to clarify one thing for the benefit of this committee. And after talking with Chairman Petrie this morning, you gave a very good argument to a question regarding separation of powers earlier this week to myself and Mr. Nacy. And if you could just explain to the court, you indicated that it was part of the procedural process. Sorry. So if you could explain the procedural process that you did for the committee members, I think that would be very well received.
I might be obtuse, but I don't know what the point of order was about. But
yeah, well, that's okay.
Okay. Oh,
yeah.
The court.
Well,
yes, Your Honor.
We're not going to make a ruling.
Yes,
so.
Yes, Your Honor. Well, I hope the ruling is aye.
Well, that'll be the vote, but not the ruling.
Sure. Well, so this is an area that Representative Kulkarni and I decided I'd answer the question. She's got answers to everything else. Just because I used to be with the Court of Justice, I was a general counsel for the Kentucky Supreme Court, in the Office of Chief Justice for a number of years. So the concern is a very valid concern, and that is that in areas of substance, the legislature makes the rules. In areas of process, the courts make the rules. In areas of evidence, because some of that's process, some of that's substance, we work together. That's Kentucky Rule of Evidence 1101. This is some of this bill addresses process, as Representative Kulkarni has outlined, and the concern is, are we overstepping our bounds in the separations of powers? And I would say I would have two responses to that. There are a number of statutes that we've passed that do address process, and we ask the court to grant that what's called comity. Comity is, even though this is within the realm of the court system, the legislature has given its approval. There's no reason for us to disagree, and as a matter of respect, we give the particular enacted law what's called comity. So we would be asking for that. But I think the more fundamental point here is sometimes the distinction between process and substance, as we've identified in how we address our rules of evidence, is blurred. And in this particular situation, the actual process is the substantive right that we're trying to address. And so if you have if I make a statement against someone and it's a matter of public concern, that's really important, as Representative Kulkarni outlined. It's only those situations. If I make a comment on a matter of public concern, and then I get sued to shut me up, well, if you let the process go forward, that is the harm to me. So that's the substantive harm that we're trying to stop. And so my response, Mr. Chairman, is those two things. One, I believe we would ask the court, and the court would grant it comity to the extent that it's necessary. But I think the more fundamental point is the process is the substantive right that we're trying to address here.
Mr. McGarvey.
Again, I come to you as one of the LRC's uniform law commissioners and its legislative liaison for Kentucky. This is a uniform act. The process by which this act was developed includes a year of study and 2 years of drafting. I have never seen an act that we adopted as a Uniform Law Commission enjoy such wide support as this one. That support ranges from the ACLU to the Americans for Prosperity. It is now before the Indiana legislature. Jim Bopp, I don't know if any of you all recognize his name, one of the most prominent capital C conservative lawyers in the country, testified in support of it. I think it could be titled an act to provide an efficient mechanism to protect the First Amendment. I don't want to waste your time, but I wanted to let you know that this is not a partisan bill, but it's a product of the Uniform Law Commission that Representative Kulkarni and Representative Nemes have sponsored, and we fully support and recommend it to you.
Thank you. Do we have any questions of the members? We have Representative Bratcher has a question.
Can you just give me an example, a hypothetical you could make up, or a real life example of where this is providing harm?
Yeah, I can provide some examples in
And I
Kentucky.
have a second question. Go ahead.
Oh, sorry. So there's a lot of different ways this can be applied, because fundamentally it will be applicable to a matter of public concern in any situation. So it's not confined to any particular cause of action. There are examples where a coal miner was essentially a whistleblower against a company for dangerous practices. The company sued the worker for defamation, and so he was defending against that underlying defamation case, which was, again, not valid on its merits, but was just designed to drain the individual of resources and try to essentially shut him up. More recently, there is an open records case that was in Taylorsville, involved the city of Taylorsville, where they sued an individual for filing too many open records requests and then publishing those records on a blog, which of course this is all public record, again, essentially to intimidate and stop the individual from publishing that information on the blog. I think there's a few more, but there's a lot of actions involving developers, changes in zoning, so you have a lot of local planning commissions and things like that involved in developers involved in suing people for defamation for comments being made in public hearings, or just statements made, or blocking zoning changes, and so they'll be sued for something like tortious interference or defamation, just to kind of, again, use up their resources and not ever get to the underlying issue at hand.
I think I get it now.
You had a follow-up, Representative?
Yeah, I'm going to be Representative Scott to this one. What's the difference between the original, which is a very good question and should be part of our process, every committee. What's the difference between the original bill you filed and what we just changed 5 minutes ago?
Sure. So on page, I believe it's in section 2, which is the exceptions, and it's number 5. So it's 2A5. In section 2, number 2A, subsection 5. Page 2. That was easier. Seeking recovery for bodily injury, wrongful death, or survival, or to statements made regarding that legal action. There was another phrase in there involving damage to reputation, which was removed because all of that is covered under subsection B of that same section.
Representative Petrie.
Thank you, Mr. Chairman. First off, I'd like to comment that I appreciate and respect the way Representative Kulkarni has marshaled this issue. She spoke with me some years ago and was persistent in the bestest of ways, and it's a good issue that's worthy of pursuit. I have several questions, not the fault of the sponsor or anybody presenting. As I spoke with you this morning, I hope that we can talk about those afterwards. Just briefly, I think there still remains some separation of powers issue that I think Representative Nemes spoke to, and whether or not procedurally we're stepping over in another branch's lane. Secondly, along with that, there are some procedural mechanisms in the bill that limits appeal time to 21 days, mandates attorney's fees and costs and other expenses upon certain findings rather than letting those be permissive, and a few other things. I hope that I can speak with someone afterwards. Again, not the sponsor's fault, not the presenter's fault, and I hope that we're able to do that. Will likely be a pass on it today, but I hope that's not a bad mark on the bill itself, because I applaud the work done and it's a good issue. Thank you, Mr. Chairman.
Thank you. Seeing no further questions, we have a motion and a second on House Bill 222 as amended by the committee substitute. Madam Secretary, please call the roll.
Representative Banta,
Yes.
Representative Blanton,
Explain my vote, Mr. Chairman. I am going to vote aye today to move it along in the process, but I will echo the concerns that Representative Petrie mentioned and hope to have follow-up conversations. I know what you're trying to accomplish, and I commend you, and I have no doubt of your work. You do meticulous work, and I appreciate that. So because of that, I'm going to vote yes to move along in the process today. Thank you.
Representative Bratcher,
Yes.
Representative Cantrell, Representative Decker,
Yes, explain my vote. I studied this issue preparing to run for office, actually, and have been concerned about it ever since. But many of the things I was concerned about, I've seen meticulously taken care of here, but I still have the same kind of concerns that have been expressed. So I look forward to hearing more about perhaps taking care of those. Thank you. I vote yes.
Representative Elliott,
I explain my vote, Mr. Chairman. I'm going to vote yes, but I do have a question as to whether or not, I didn't ask it during the discussion, but I do have a question as to whether or not a matter of public concern is of such importance that we should limit the ability of someone to go through the litigation process. So I'm going to vote yes, but I would like to have that discussion with you, and I thank you for your work.
Representative Fisher,
Yes.
Representative Heverin, Representative Colcarney,
Yes.
Representative Lewis,
Yes.
Representative Maddox,
Yes.
Representative McCoy,
Yes.
Representative Minter,
Yes.
Representative Mosier,
Yes.
Representative Nemus,
Yes.
Representative Petrie,
Mr. Chairman, briefly, I will vote yes because I admire the work done and it's a good issue. Again, I need a further discussion before I make a decision on the floor. Vote yes for today. Thank you.
Representative Scott,
Yes.
Representative Stevenson, Chairman Massey.
Yes. There being 18 yes votes, 0 no votes, and 0 pass votes, the same will be reported with favorable expression that the same should pass. I want to echo the good work that you've done on this bill. Complicated bills rarely go forward without having changes along the way, and we know that that's a case, so I wanted to make sure we took the time today to make sure this committee understood what you were trying to achieve in your bill. So thank you for that.
Thank you, Chairman. Thank you, members.
This will pass with the committee sub, House Bill 222. Also, for members, we've requested several bills. We've received a few. I'm just trying to give you a heads up on what to look at in the days to come. Likely next week we will hear felony mediation. We may hear the fentanyl bill that was initially scheduled on our first agenda and was pulled. We're working out some details there. We have requested the student rights bill and a few others. So as I get more information through the week, I will try to send you a text or an email and let you know so that you can read those bills in advance and be prepared. Thank you, members. Thank you, audience.